In this case, Butera was one of a number of people charged with conspiracy to traffic in heroin. Part of the evidence was a recording of a conversation among the conspirators. The conversation was conducted mostly in the Punjabi language, with some English and some Malay. The judge allowed into evidence written translations of the contents of those recordings, put into evidence by expert translators who were also available to give oral evidence in court. Ordinarily, oral evidence is regarded as the gold standard of evidence, particularly in criminal proceedings. The majority judges in this case set out the rationale for why this is so. They said, a witness who gives evidence orally demonstrates for good or ill more about his or her credibility than a witness whose evidence is given in documentary form. Oral evidence is public, written evidence may not be. Oral evidence gives to the trial the atmosphere which, though intangible, is often critical to the jury's estimate of the witnesses. By generally restricting the jury to consideration of testimonial evidence in its oral form, it is thought that the jury's discussion of the case in the jury room will be more open, the exchange of views among jurors will be easier, and the legitimate merging of opinions will more easily occur than if the evidence were given in writing or the jurors were each armed with a written transcript of the evidence. However, a transcript can be used as a device to enable jurors to understand the recorded evidence. The majority judges said that if this happened, the jury should be instructed that the purpose of admitting a transcript is not to provide independent evidence of the conversation, but so as to aid them in understanding what conversation is recorded on the tape, and that they cannot use the transcript as a substitute for the tape if they are not satisfied that the transcript correctly sets out what they heard on the tape. Obviously, though, things are a bit different if we're talking about a recording in another language, and in this case the translations came to over 500 pages. The court found that in those circumstances the rules were not ironclad, and the only realistic path was to allow the written translations into evidence.